Hello again, this is Alan Tippie. Thank you for your patience. We did have a couple of additional people who joined by delaying a couple of minutes. And so we're going to start. Obviously, for those of you, hopefully, that are on the line, you're here for the webinar on the ins and outs of real estate bankruptcy sales. Again, this is Alan Tippie, and I'm just going to walk through some of the issues that we've covered in our outline. And obviously, there are opportunities to present questions at the end. You can also present questions during the webinar, although it's going to be difficult for me to pick them up and deal with them during the webinar. So if you have questions that you'd like to pose, we'll address those at the end, and you can also pass them on to me later on. You'll have my contact information. You have it in the materials that have been circulated. For those who are looking to get MCLE credit, we have making arrangements for that credit to be provided to you. Anyway, let's get started, and we'll just talk about some of the things that we've set forth in our outline. Again, the topic is real estate bankruptcy sales, and the discussions that we're going to have today will deal actually with sales of assets that aren't real estate, but the focus of attention primarily is on the real estate sales today. The first thing that we're going to talk about is, where do these sales generally take place? We mentioned Chapter 11 and Chapter 7 in the outline. There actually are sales that take place in other chapters of the Bankruptcy Code, including 12 and 13, certain limitations in Chapter 13. However, the most common place where most of us would get involved in bankruptcy sales would be in a Chapter 7 or Chapter 11. I presume most of you know the difference between 11 and 7. I'll, however, just take a moment to briefly describe. Obviously, at Chapter 7, there are trustees appointed immediately upon the commencement of the case. There's a provision of the Bankruptcy Code, Section 541, that talks about what assets become part of a bankruptcy estate. Obviously, real estate owned by the debtors immediately becomes an asset of the estate on the commencement of the case. And the trustee in a Chapter 7 is tasked with the responsibility of liquidating all assets and making distributions to creditors. So to the extent there are real estate assets in a Chapter 7 case, there is a likelihood, strong likelihood, that those assets will be sold. I say strong likelihood because there are obviously circumstances where the real estate assets are over-encumbered, or there are tax consequences that will exceed the net equity in the property, and consequently the trustee will not sell the property because the trustee will not conduct a sale where the trustee is incapable of paying administrative tax obligations in connection with liquidations of real estate. Chapter 11's the general rule, obviously, is a debtor in possession is the person that is in charge, or the fiduciary for the bankruptcy estate, and that debtor in possession is generally management of the debtor that existed prior to the filing. Under certain circumstances, however, a trustee can be appointed, and so we will either have a debtor in possession or trustee that would be looking to liquidate assets in a Chapter 11 case. Chapter 11, however, as you know, is a reorganization case, so liquidation of real estate isn't necessarily the goal. In a Chapter 11 case, it may be to retain that real estate or to refinance it, do something else in the bankruptcy, but statistics have shown that Chapter 11 cases generally end up, I think, about 17% are successfully reorganized, and the remainder of them end up in liquidation, dismissal, or otherwise. So if there is a real estate asset in a Chapter 11 case, there is a likelihood that a sale will take place also in that situation. Now, going again from the two situations where we would find real estate sales, let's go on to how those sales take place. Provision of the Bankruptcy Code, Section 363, provides and gives authority to a trustee as well as to a debtor in possession to sell property of the estate. The first section that we're going to look at is Section 363B, which is the section that deals with sales out of the ordinary course of business. When it comes to real estate, more often than not, a sale of real estate will be out of the ordinary course of business. To the extent that you, however, have a debtor whose business is in the sale of real estate, for example, a real estate developer who has developed a project and the process of operation of the business includes sale of real estate, that sale could take place under Section 363C, which authorizes the sale in the ordinary course of business. However, the situations in which that would arise are probably slim. Not only because there are not that many debtors that are in that business of selling real estate, but frankly, just from a practical standpoint, a title insurance company, and obviously you will want title insurance as part of any sale of real estate, a title insurance company is highly unlikely to issue a title policy in connection with the sale of real estate that is part of a bankruptcy case without a court order authorizing the sale. So while 363C may authorize the sale without notice in a hearing and a court order, again, the circumstances under which that will arise are probably non-existent. And so first of all, let's look at some of the issues that come in connection with the sale. The first thing that the court has to determine when the trustee seeks to sell, trustee or debtor in possession seeks to sell property out of a bankruptcy estate, is that the asset is itself an asset of the bankruptcy estate. That may seem like an obvious question, but it isn't always true, because there are parties who may take the position, and there have been cases that are issued that deal with contested claims to ownership. And so one of the first things that has to be addressed is the court must first determine that the asset, if subject to dispute, is in fact an asset of the bankruptcy estate and therefore may be sold by the trustee. That determination is to be made prior to any other issue in the case, and so therefore there may need to be a contested proceeding or an adversary proceeding that is initiated in order to resolve that dispute. The second thing that generally comes up is the type of sale that the trustee or debtor in possession may attempt to accomplish, which is public or private sale. Most sales in bankruptcy are public sales. There are, however, certain private sales that do take place and that are not intended to be available for auction or overbid, but the general rule is that sales will be conducted publicly and subject to overbid, which we'll discuss a little bit later in the webinar. One of the other things is that in order to conduct a sale under Section 363B is that there must be notice in a hearing, which is defined in the Bankruptcy Code to be notice as appropriate under the circumstances in a hearing if necessary, to the extent that a hearing is either requested or, more often than not, when the motion is filed, a hearing is scheduled. Again, it is generally the better rule, because while there are theoretical concepts that you can sell assets without a court order, to the extent that nobody objects, that doesn't really apply from a practical standpoint in real estate sales. Notice, however, is an important aspect of obtaining a court order. There are cases that indicate that if notice is not properly given, court orders authorizing sales may be vacated. For example, if you sought to sell a property and didn't give notice to one of the lien holders on the property, or didn't give proper notice, for example, to an insured depository institution, which requires notice by certified mail under Bankruptcy Rule 7004H, notice may be deemed to be improper, and a sale could be set aside for improper notice. The other issue that may come up is the terms of the sale, or whether or not the sale is of substantially all of the assets of the bankruptcy case. There are a number of cases over the years that talk about whether or not a sale of substantially all of the assets of a bankruptcy case is appropriate In a Chapter 11 case, short of a Chapter 11 plan, most of those cases look to the particular facts, determine whether or not the terms of the sale are intended to be, in essence, a substitute for a plan or a sub rosa plan. More often than not, the attorneys that present these types of motions to the court are not going to make the mistake of trying to put those kind of provisions in sale motion, and so consequently, even though the sale may be of substantially all of the assets of the estate, the court will nonetheless consider it and approve it if it is appropriate. We can talk a little bit about, again, ordinary course of business, but I think we shall skip over that and move to some of the other issues. The value of selling property in a bankruptcy estate, as contrasted with outside of bankruptcy, is that the buyer may be looking for a comfort level, particularly if there are disputes as to liens, ownerships, or other issues affecting real property, that it may obtain some type of imprimatur of the court authorizing a sale, identifying it as a proper buyer, and giving it certain protections that aren't otherwise available outside of a bankruptcy case. And so most motions, I say most motions, maybe not most motions, many motions are filed to sell real estate free and clear of liens, or free and clear of interests, which generally include liens. And whether or not the liens are disputed, the motions generally request that the sales be free and clear of liens, merely because there may be a dispute as to the amount of the claim, even though you don't dispute the claim itself or the lien against the property. And so 363F of the Bankruptcy Code is utilized in most sale motions in which a request is indicated in the motion that the sale or the motion is seeking a sale of the property free and clear of liens. Again, that is also provides a comfort level to the buyer that it will not need to be concerned about any liens or claims against the property, because it will have an order of the bankruptcy court that authorizes a sale free of any such interests or claims. There are a number of ways to do that, a number of ways to sell free and clear. We've identified the most common ways in the outline. Again, it's under 363F. 1, consent by the interest holder. 2nd, the proceeds exceed the aggregate liens on the property. And the 3rd is the interest or the lien is in bona fide dispute. There are 2 other subcategories under 363F. We're not going to deal with those today. We'll deal with the 3 most common. These 3 that we're going to address, by the way, and all of the 5 in the Section 363F are in the disjunctive. So you need not satisfy all of them. You only need to satisfy one of the subsections of this subcategory of Section 363. First, again, consent by the interest holder. Pretty obviously what it means is, to the extent you actually get consent, affirmative consent by the interest holder to sell free and clear of its interest, then you have satisfied the requirement of 363F, and the court may issue an order authorizing the sale free of that lien. The second way of obtaining consent, as determined by case law, is that if proper notice is given to the lien holder or interest holder and no objection is filed by that lien holder, that consent is deemed given, and so you can satisfy consent by failure to respond to the motion, which again goes back to the importance of making sure that that lien holder is properly served. The next option are the proceeds of the sale exceed the aggregate liens on the property. Now, obviously, there may be a number of liens on the property, and one may consent to the sale, another one may be in dispute. A third, again, has a different issue. But if you can sell the property and the proceeds will exceed all of the aggregate liens on the property, you have a separate category in which you may obtain an order of the court selling free and clear. Now, the cases talk about whether or not the words used in the statute, aggregate liens, means in fact all of the liens against the property. Namely, if one of the lien holders actually consents to a sale free and clear, do you need to necessarily determine that the sale is for proceeds that exceed all liens on the property, and the answer depends on where the lien is. If it's the most junior lien and they consent to the sale, you don't need to demonstrate that the proceeds will exceed all the liens on the property, but at least the liens that are senior to the consenting liens, so that you can set aside proceeds sufficient to satisfy those liens to the extent they are ultimately determined to be allowable in the amounts. The second issue is whether or not the liens relate to claims against the property, because under 506 of the Bankruptcy Code, you can essentially segregate a secured lien into a secured and unsecured portion. The question becomes whether or not you need to have proceeds that equal or exceed the aggregate liens as determined under Section 506, or whether or not it is the liens that are against the property. And the answer is that you need to satisfy the requirement as to the face amount of the liens, regardless of whether or not the claim may be undersecured. If the court ultimately enters an order authorizing a sale free and clear of these liens, you need to demonstrate that the proceeds of the sale will be set aside and that the liens of these interest holders or lien holders will then attach with the same priority, enforceability, and effect as they attach to the real property. Issues have come up in motions as to whether or not then the debtor in possession can take possession of those cash assets and segregate them, whether or not the money has to be retained in an escrow account. For most of the cases that I've dealt with, in fact all of the cases, I've never been in a situation where the debtor in possession has not been deemed to be an adequate fiduciary for the estate and has thereby been entitled to retain the cash proceeds for purposes of satisfying the requirement that the cash proceeds be set aside. An issue that doesn't come up very often, however, but may come up, particularly if you're a lien holder and are concerned about the ability of the debtor to pay you later on, a debtor who has, or a trustee who has disputed your lien, is whether or not the continual accrual of interest on your claim is protected by the amount of money that is set aside. Say, for example, the aggregate liens against the property are $4.7 million. Debtor demonstrates that the net proceeds are $5 million. The question then becomes is how long will it take for interest to accrue on those liens and claims that haven't been satisfied before that $5 million is now inadequate, particularly if you're in an adversary proceeding litigating the disputes with respect to liens against the property that haven't been satisfied from the proceeds of sale. Again, it's an issue that should be brought up by secured creditors and something that will be required from an adequate protection standpoint. The last option is the interest in bona fide dispute. Again, an option to sell free and clear of a lien. Question is, what interest could be in bona fide dispute? Well, for example, a lien against property that may have been recorded within a preference period, 90 days prior to the bankruptcy, that may be subject to avoidance. There may be issues as to whether or not the description in the deed of trust was sufficient to create a lien against the property, and so you may challenge it on those grounds. There may be other reasons why you challenge liens against property. In order to sell free and clear utilizing this subsection of 363F, however, it is incumbent upon the moving party, trustee or debtor in possession, to demonstrate that the interest in bona fide dispute, and because Rule 7001 requires that disputes regarding liens be the subject of adversary proceedings, it would be necessary prior to the hearing on the motion to initiate that adversary proceeding to challenge that interest of the party to whom you wish to sell free and clear, so that that adversary proceeding is on file before the hearing. Just raising the issue or identifying the facts may be insufficient. You may be required, and the better course of conduct would be to initiate the adversary proceeding prior to the hearing. Okay, let's move on and talk about sales of a co-owner of property. In addition to the sale of real estate that is owned by a bankruptcy estate, the debtor in possession or trustee can sell the interest of co-owners of property. There are certain requirements, however, before you can do this, and this is a very unique aspect of sales, because obviously this opportunity doesn't exist outside of a bankruptcy case. Anyway, the sale of co-owners' interest in property, there are a couple of issues. Let's first of all, again, number one, we talked about adversary proceedings in Rule 7001. In order to sell the interest of a co-owner who does not consent to the sale of its interest, the trustee or debtor in possession needs to commence an adversary proceeding. Again, Rule 7001 indicates that this type of proceeding can only be done by a complaint and cannot be done by motion, and so you have to give yourself sufficient opportunity to commence that adversary proceeding and obviously seek to have it expedited if you intend to close an escrow for the sale of the entire asset within a reasonable period of time. The requirements, let me just say, if the co-owner consents, obviously the adversary proceeding is not necessary. The requirements in order to sell the co-owner's interest, again, is number one, is the partition of the property would be impracticable, which is sort of a combination of practicality and possibility. In many cases with respect to real estate, partition is not practicable. And so you have to look at the situation. For example, if you had a condominium complex that could easily be divided, certain condominiums amongst certain owners and other condominiums allocated to the debtor or the bankruptcy estate, that might be possible. However, you then have to look, is there an overlying deed of trust against the entire property where the lender is certainly not going to find it acceptable that its collateral is divided up amongst two owners as contrasted with what existed on the day of the bankruptcy filing. So the lien may pose a problem even if dividing the property up is practicable from the standpoint of, again, being able to easily divide or discern certain assets and allocate them from one owner to the other. Obviously, single family residences, office buildings, things of that nature, it's highly unlikely that you'll be able to, from a practical standpoint, divide them up or partition them, and so consequently, again, the aspect of partition probably is easily satisfied generally when it respects real estate. There are obviously exceptions, but for the most part, you probably presume that partition is not practicable. Second, you also have to show that the sale of the estate interest alone would realize significantly less. Namely, if the debtor in possession owns a tenant in common interest in a piece of property, we'll have to demonstrate that the sale of that tenant in common interest, which may be a minority interest, would realize significantly less, not less, but significantly less than if the parcel or the property or the asset were sold as a whole. Again, you may need appraisers to demonstrate that to the court or real estate brokers to talk about what the assets might realize, again, sold as a partial interest versus 100% interest. And last, the sale does not involve electrical energy or gas. Now, one of the things that comes up as a combination between the sale of co-owner's interest and 363F that talks about a sale free and clear is what impact does the authority under 363G give to the power available under 363F to sell free and clear. I have filed motions to sell the interest of co-owners as well as the interest of the debtor's estate and asked that the properties be sold free and clear of all liens and interests against the property. And in the absence of an objection by any of those parties, the court actually entered an order, and I was able to obtain a title insurance policy that allowed me to close the sale. But frankly, I don't think the law authorizes it. If you look at Section 363F that authorizes a sale free and clear, the section only deals with a sale free and clear of an interest of the debtor, debtor's interest in the property, not of that of a co-owner. And so consequently, if you have property that is co-owned and is being sold pursuant to Section 363, the question has become is, can you utilize that section to sell free and clear of the interests of the co-owner and not satisfy those liens? And I think by reading the statute, the answer is no. Collier's also indicates that the answer is no, and so consequently, you may be limited in your ability to use 363F if the motion also includes a sale of interest not owned by the bankruptcy estate. One of the other points is that the offset or the consideration or the exchange that is given under the bankruptcy code to allow the debtor or trustee to sell the interest of a co-owner, the counterpart is it gives the right of first refusal to the co-owner to buy the property at any price that another party is willing to pay for the property, and that is under Section 363I. And so consequently, as the trustee or debtor in possession is marketing the property for sale, the broker should frankly notify any prospective buyer that the property has a right of first refusal attached to it that is created by statute, so that any buyer has to understand that to the extent that they make an offer, that they engage in due diligence, that they expend money, attorney's fees, etc., in connection with the purchase of the property, they may not ultimately be the purchaser, even if there are no other overbidders, because there is a right of the co-owner to buy the property on the same terms and conditions. Again, this may chill the bidding, but nonetheless, that is a provision in the bankruptcy code that exists and must be taken into consideration in connection with the sale. Next, let's move on to the lien holders may bid at a sale. That's under Section 363K. Lien holders against the property, again, may bid at sales, and the most common is that you have a deed of trust against real estate where the deed of trust holder can essentially bid its claim against the property, whether it be undersecured or oversecured, can bid it against the property in order to purchase the property. Obviously, if the purchase price is in excess of the lien that is being bid, there will have to be additional cash consideration contributed as part of the sale. And there are also issues. Number one, it only applies to Section 363B sales, which for the most part is what we're talking about today. It does not apply to sales in the ordinary course of business. The second option is that the lien cannot be in bona fide dispute. If the lien is in bona fide dispute, which is an issue that will be raised obviously by a trustee or debtor in possession, if it objects to the credit bid, then the court will determine whether or not a bona fide dispute exists, and if it does exist, may also prohibit the lien holder from bidding in at the sale. There are also issues as to whether or not, for example, there are multiple sales of property or multiple properties that are available for sale. The lien holder may have a lien against one of the properties but not against another property. It cannot bid in its lien to purchase property in which it does not hold a security interest. And so if the sale is proposed of a package of properties and that is just the best way to present that sale, the court may also prohibit credit bidding under those circumstances because it may create confusion as to exactly whether or not the bids are comparable from one another, particularly when one of the bids includes a credit bid of a lien holder. Let's move on then to a protection of good faith purchasers. The Bankruptcy Code, Section 363M, provides that if a purchaser of real estate has purchased the property in good faith, that any appeal taken to an order authorizing that sale will have no effect on the validity of the sale. Namely, a reversal or a modification on appeal will not cause that sale to be unwound if the purchaser is in fact acting in good faith. Now, the issue then becomes is how do you determine whether or not they've acted in good faith? The court will generally hold a hearing in which it asks questions such as, is the purchaser in any way related to the debtor, the trustee, any of the creditors of the estate, have any connections whatsoever? Are there any other issues that, for example, may affect whether or not the purchaser acted in good faith? For example, was there any collusive bidding? Was there any other actions taken by the purchaser for which it will be deemed not to have acted in good faith and thereby not entitled to protections of 363M? The other issue is, again, it has no effect on the validity of the sale. The question is, does it have an effect, for example, on the sale free and clear? Because the sale free and clear under 363F is a different aspect of the sale order that authorizes the sale to the buyer, but doesn't really affect the transaction itself, but affects the payment of the claims that were secured by the property. So the cases have indicated that while 363M will protect a good faith purchaser from a reversal or modification on appeal with respect to the validity of the sale, the appeal may still go forward with respect to challenges, for example, as to whether or not there is a satisfaction of one of the subsections of 363F in connection with the request to sell free and clear of liens. The second aspect, obviously, is no stay is issued. Namely, if a party in interest who has standing to appeal seeks a stay, the 363M protection obviously does not protect the buyer, and if the sale will not close anyway, and so consequently it's not as if a buyer has closed the transaction, has paid the purchase price, and then has to be faced with the likelihood of the reversal or modification of the sale order, because the stay will put a stay on closing of the sale. And again, so from a practical standpoint, the implications of reversal or modification probably don't have the same effect because the sale hasn't closed. The issue, however, and I've added in here, it's not part of the bankruptcy code, but there's practical implications of 363M. Number one is that any any sale order, any order of the bankruptcy court is subject to appeal for a period of 14 days. And so consequently, while the court has the authority to waive that 14-day requirement, so a sale, for example, could close the next day, the day after the entry of the order, title insurance companies many times want to wait 14 days regardless, just because there could possibly be an appeal filed and, frankly, a stay issued on the 13th day. And so title insurance companies are reluctant to close prior to 14 days. The other part of it is an appeal taken to a sale order. While 363M may have provisions in the order that indicate that the buyer is a good faith purchaser and therefore it has the protections of that subsection, title insurance companies may nonetheless refuse to issue a title insurance policy because they aren't confident that they are protected by this order and consequently will not issue a title insurance policy and thereby prohibit the sale from closing, because title insurance is obviously an essential element of a real estate transaction. The other aspect of the order granting the sale is that to the extent that the bankruptcy judge makes a finding of good faith, that aspect of the order can also be challenged on appeal, where, for example, the court did not take evidence as to whether or not the buyer, in fact, was acting in good faith. And when you think about practical implications, again, you have a motion that you file with the court, you have a buyer that you present to the court, 2 or 3 other buyers show up as qualified overbidders. There's an overbidding process. Ultimately, one party, possibly not the original buyer, becomes the successful purchaser of the property, and within a matter of minutes, there is a question asked by the attorney for the trustee or the debtor in possession of the buyer, asking questions about connections to the estate, connections to creditors, the activity or the actions taken by the purchaser in connection with the sale. And based on those couple of minutes of questions, the court makes enters an order or a finding of good faith, which ultimately may be challenged on appeal. And so title insurance companies should also be concerned about whether or not that aspect of the order gets reversed on appeal, and therefore 363M does not create the protections for the buyer, and namely the protections for the title insurance company. And so for those of you who wish to challenge sale orders, you need to challenge aspects of the sale order that are not that are not protected by Section 363M. For example, orders authorizing sales free and clear of liens under 363F, the good faith determination under 363M, and things of that nature, particularly if you want to be disruptive to a sale and utilize it as leverage potentially in connection with trying to gain some advantage in connection with your objection. Now, we talked a little bit about collusive sales. Obviously, if it's a collusive sale, there will not be a finding of good faith in connection with the purchaser. If the collusive sale was obviously, if the purchaser was participating in the collusive sale. Collusive sales may be avoided even after the sale order is entered under 363N. Now, collusive sales doesn't necessarily mean that there was an agreement between the buyer and another party in connection with the sale. Maybe there was a joint venture essentially entered into in connection with the sale where the two parties decided to aggregate their buying power in order to make sure that they purchased a property together. That in and of itself will not be deemed to be collusive unless that agreement also had something to do with trying to control the purchase price of the property or control the purchase price, which then would be deemed to be collusive. Alternatively to avoiding the sale, there may be a recovery of the lost sales proceeds. Again, simply the answer is, had there not been collusion affecting the sales price of the property would have sold for a different price. The delta between the two can be the recovery to the bankruptcy estate from collusive sales rather than avoiding the sale, which frankly then requires that the estate to take the property back in, insure it, possibly put it back up for sale again, maybe things that the trustee or debtor in possession doesn't wish to do. Importantly, however, is that the award, in addition to lost sales proceeds, may include costs, attorney's fees, expenses, and even punitive damages under appropriate circumstances. So, for those out there who may be inclined to engage in collusive bidding, you have to understand there can be significant consequences. Bankruptcy courts do not take kindly to collusive sale agreements. Okay, let's move on to the next section. Chapter 11 plans, again, in addition to Section 363, a Chapter 11 plan may provide for a sale of property. There is, under these circumstances, a mechanism for creditors to facilitate sales of real estate in a Chapter 11 case. And the reason why I say that is because Section 363 obviously only gives authority to the trustee and the debtor in possession to move to sell property, not creditors committees, not individual creditors, secured creditors, etc. Secured creditors can obviously seek relief from stay in order to conduct foreclosure or trustee sales, but they cannot facilitate sales to third parties except, again, under their enforcement of their lien rights. But in a plan, a creditor can file a plan that includes a provision to sell real estate, and so that's the opportunity where a creditor or a party in interest can move to sell property. However, you have to understand, if you're selling under Section 1123 or pursuant to a plan, that many of the provisions of Section 363 or all the provisions of Section 363 may not apply, such as sales free and clear, good faith protections, and things of that nature. Because you're not selling pursuant to Section 363, you're selling pursuant to Section 1123. The other disadvantage, of course, is to creditors or parties in interest presenting plans that include sales of real estate is that you can't just focus on the sale of the real estate. You must address all claims in the estate, which is a lot more work than, frankly, a lot of creditors want to engage in when all they're trying to do is liquidate the asset in which they may have a lien or which they look to see may be a source of proceeds for payment of their claims. Okay. Procedures to notice a sale. More often than not, there are the sales will include an opportunity for an overbid. Whether there will be an overbid or not, you can't necessarily tell in advance of filing the sale motions, but there may be other bidders who will come in and seek to bid at the sales. The question becomes is, do you put the bidding procedures in your sale motion, or do you file a bidding procedures motion prior to the sale? More often than not, the bidding procedures are included within the sale motion because the sale may be of residential real estate that's worth $1 million or $1.5 million, or some other asset that doesn't have that much value to it. And so consequently, filing two separate motions, it just increases the cost of that process. And so the bidding procedures will be included within the sale motion. Bidding procedures, of course, have to deal with qualification of overbidders, what is required in order to qualify. For example, how much deposit do you have to put down? Do you have to demonstrate that you have the financial wherewithal to close? And other things of that nature. And so you qualify prior to the hearing. The better approach, particularly when it deals with larger parcel property, more expensive properties where you really want to make sure that the bidding procedures are established prior to the hearing on the sale, is you file a motion prior to your sale motion setting forth bidding procedures that you ask that the court approve. And that way, when you get to the sale hearing, there'll be no issues with respect to whether or not your proposed overbid amounts, for example, are acceptable, whether or not the initial overbid is acceptable, whether or not the deposit that you require is acceptable, and things of that nature. And that's the question with respect to timing and notice, is when do you do it, and who do you give notice to? Now, the setting the amounts of the initial and the subsequent overbids is a process many times where the trustee will establish those numbers his or herself, depending on the value of the property and what the likelihood of enticing an overbid without discouraging overbids. So the initial overbid essentially should be something to entice but not discourage, and subsequent overbids generally are less than the initial overbid, again to entice bidding because the goal is to secure the highest and best price for the property. And so consequently, you want to set those numbers to encourage overbidding. The buyer, however, and what we'll call the stalking horse buyer, we'll get to that in a moment, may want to participate in setting those numbers because obviously the stalking horse buyer wants to make sure that the numbers are set to discourage overbidding. And so consequently, to the extent that you represent a stalking horse, you may want to negotiate with the trustee in the terms of the contract what you would like to see as far as initial and subsequent overbids. Again, for the purposes of trying to discourage it, but at the same time, obviously, if you become too unreasonable, the trustee will simply say no and submit its own initial and subsequent overbid amounts to the court. Obviously, your choice at that point in time is to then just indicate that you're not willing to move forward with the sale if those numbers are not acceptable to you. Next thing with respect to, again, nuances of sales is that sales out of bankruptcy cases generally are as is, where is. And that's for a number of different reasons. It could be because a trustee is the seller, and the trustee obviously doesn't have a history with the property, may not be intimately familiar with certain aspects of the property, and wants to make sure that the onus is put on the buyer to accept the risks attendant to purchasing a property that the trustee will not potentially be able to give full disclosure with respect to issues that may be important to it. And so you need to understand that purchasing property out of a bankruptcy estate may have risks attendant to it that don't otherwise exist, although contracts outside of bankruptcy also have those same provisions in them. Standard contracts have those provisions. It becomes a little bit more enforceable, so to speak, from the standpoint of not only the trustee will insist upon putting in waiver of many contingencies and waiver of rights, but obviously very clearly focusing on this as is, where is. The other aspect of purchasing property, trustees generally do not like to submit motions to sell property to the bankruptcy court until he or she knows that there are no contingencies that will affect the closing of the sale. Why? Because to go to a hearing that is for a sale of real estate, if your stalking horse buyer has not waived contingencies, you don't even know whether your stalking horse buyer will close the sale in the event that the court approves the sale to that buyer. It becomes even worse where you have multiple overbids, and maybe the sales prices increase substantially, 10, 20, 30% during the overbid process. But if you still have contingencies that are part of the sale process, again, it creates a lot of uncertainty with respect to bankruptcy sales. And one thing about bankruptcy sales, you like to have certainty. Certainty because you need to move forward with the case. Certainty because you don't want to lose the other potential buyers that were willing to purchase the property that may have been willing to waive contingencies. And so the likelihood of going to court and including contingencies is not high. Most trustees, again, will wait till the contingency period and the inspection periods have passed before the motions will be filed. That isn't an absolute, but it certainly, from a practical standpoint, is the way that most debtor in possessions and trustees will approach sales. Again, we talked a little bit about the lack of information or materials by the seller or trustee. Again, because the seller or the seller trustee or the debtor in possession theoretically will know its own property, but a trustee may not. And so the trustee may not be able to give you information, building permits, other types of things that may be relevant to the property because he or she doesn't have them, which just emphasizes the importance for extensive due diligence. You have to presume, if you're buying a property out of bankruptcy, particularly from a trustee, that you need to satisfy yourself that the property satisfies all of the conditions and that you have, for example, conducted soil tests and phase 1, maybe phase 2, that you've done inspections of any improvements on the property, that you've checked out zoning, that you've checked out everything with respect to the property, because later on you will not be able to go back to the trustee because the trustee will have had you waive all contingencies and the property is sold as is, where is, and so consequently you don't want to be in litigation on the basis of fraud against a trustee who, again, may have limited information about the property. The other aspect of it is you may be buying the property from either a trustee, a bankruptcy estate that is in the process of liquidation and therefore will not have assets remaining to respond to any claim for fraud or other types of misrepresentation, or a debtor in possession that is selling property that also may be through a liquidation and consequently will also be closed and not have available resources to respond to any claims that you might have. Next, let's talk a little bit about overbid issues. Again, the stalking horse position. There is some familiarity that you should have if you're going to be the stalking horse in connection with a piece of property. As I say, most properties that are sold in bankruptcy settings are likely to be subject to overbid, and so you need to understand, while you may have negotiated the exact deal that you want with the trustee, you may not be able to get that deal approved by the court if somebody shows up to overbid. And so in order to protect yourself against the expenditure of due diligence for professionals, attorneys, drafting purchase documents, for example, other type of inspections and things of that nature, that you may want to negotiate a breakup fee or a topping fee to protect yourself against having done all of that work only to find out that you are not the purchaser of the property and you've now expended $50 or $75 or $100,000 in doing your due diligence. So the question becomes is you need to negotiate that, which unfortunately for many stalking horse buyers, they don't do that. So they may find out that they've frankly lost that opportunity, because if you don't ask for it up front, it will not be approved later on. So the question becomes amount. Amount generally will be tied to out-of-pocket expenditures. The goal is not to reward the stalking horse with, for example, a profit over and above out-of-pocket expenditures, although the court may approve some amount of money paid to a stalking horse merely for purposes of essentially bringing the sale to the table in order to generate interest of other buyers. Enforceability, again, the enforceability goes back to the issue as to whether or not you've filed the motion for bidding procedures prior to the sale motion. If you have done so, you want to include those breakup or topping fees as part of that motion. If you wait until the sale motion, the court may, particularly if it has overbids, say, now that we have overbids and we have a purchase price in excess of the stalking horse purchase price, I don't need to approve your breakup or topping fees because they're no longer necessary for me to generate interest in the sale of property. So again, if you have breakup fees, particularly of a significant amount, you're going to want to get those approved in a pre-hearing bidding procedures motion rather than in the sale motion itself. There are situations where you can ask that there be no overbids, namely you think you're paying a premium for the property, so you ask that no overbids be included in the motion to sell. Trustees will accept those under certain circumstances. There may also be a request to the stalking horse that you share your due diligence materials with other prospective purchasers, particularly because the other prospective purchasers are going to be required to waive their contingencies when they submit their offers overbidding your purchase price. And the advantage or the lack of downside to that is that you will be compensated for the due diligence materials in the event that you aren't the successful purchaser. And if you share them and you are the successful purchaser, again, the advantage is you've actually acquired title to the property, and so you shouldn't be concerned about having shared your due diligence materials. Again, the overbid process, for those who represent stalking horses, you're going to be, for those who represent overbidders, you're likely to be asked to mark up the proposed APA to indicate what changes you make to it. Obviously, one of the obvious changes is generally purchase price, but there may be other things. You may add a contingency. You may add a broker's commission in different than what the broker's commission is under the stalking horse proposal. You may have closing delays, closing issues that also affect it, and so consequently you need to mark that up. And then there's an impact of or implications that will be created by whatever terms you modify, closing date, down payment, broker's commissions, etc. It is ultimately up to the trustee as to whether or not your overbid, even if a higher price, is something that the trustee will recommend to the court, because ultimately your overbid, while it may be a higher price, may have more uncertainty to it. For example, most of these sales only have a non-refundable deposit with them, and if you have a closing date that is 120 days out, it may not be acceptable for the trustee to accept a non-refundable deposit, whereas it could, in contrast, accept a lower purchase price and know that we have a closing within 30 days. So again, you have to think about the implications or the impact of the modifications of your terms. Contract terms, I'll just try to do this very quickly because our hour is just about ended. Contract terms that you generally will see that are requested by a trustee, not necessarily by the buyer that submits the offer to the broker in connection with the sale, are it has to be subject to court approval. Namely, there may be a limitation on damages or a limitation on rights of the parties. Generally, trustees require that the limitation be that for any reason the sale is not approved, that the entitlement of the stalking horse is to a return of its deposit and can make no claim for other damages. Expect that provision in a response or a counter proposal from a trustee. Again, overbid process, we talked about that, as you have to understand it's subject to overbid, and you want to negotiate, if you're the buyer, the terms of the overbid process, qualifications, initial overbid, subsequent overbids. And the last and most unusual, at least with respect to trustees, right to withdraw consent. Namely, the trustee many times will include a provision that simply says, I have the right to withdraw from this deal for no reason whatsoever if I just feel I wish to do so. Now, generally, there will be a reason. They won't want to withdraw just for any reason, but it could be, frankly, they miscalculated the tax consequences of the sale. They now realize that the tax consequences are more significant, and therefore they don't want to close a transaction for which there are insufficient proceeds to pay the taxes. Or there may be some other aspect that this property now is more important to facilitate a reorganization where another party requires the property and other considerations are being given that allows a reorganization as contrasted with the liquidation, and therefore the trustee wishes to withdraw consent to the sale. So again, you have to be aware that trustees may request that. Your buyer may find that completely unacceptable, but don't be surprised if that provision is in there. Now, I do have other issues with respect to retention of professionals. Because we're at the end, I'm just going to quickly run through them. Again, when you select a professional to sell your property, you need to think about the type of property that you're selling, timing of the sale, for example, whether or not you have to close a sale quickly. You may want to employ an auctioneer as contrasted with a real estate broker who's not familiar with auction processes. You want to obviously pick somebody who's familiar with the type of property. Maybe it's maybe it's an automobile dealership. Maybe it's a hospital. Maybe it's something that again has a unique type of aspect to it that you want to, or golf course, where you want somebody who's experienced in those type of sales, and you want to have somebody who's experienced in bankruptcy sales in general. Because you as a professional, particularly if you're representing the trustee or debtor in possession, don't really want to have to sit down and educate your professional as to all the nuances of some of the things that we've just gone over. So it's really helpful, frankly, to have somebody who's experienced in bankruptcy. And then obviously you need to go through the same professional requirements as that the professional that the trustee or the debtor in possession seeks to employ must be disinterested. I can raise issues of dual representation. I know it's very common in the industry, but you have to think about that from the standpoint of the disinterested requirement under Section 328, and you must fully disclose all contacts, because the failure to disclose contacts and relationships have resulted in denial of broker's compensation, even where the sale was a significant success and where there was maybe even a 100-cent plan presented. The broker may nonetheless lose compensation for failure to disclose information, and most importantly, you need to be employed by court order. There are a number of cases out there that talk about denial of broker's compensation for having failed to be employed on a timely basis. And I see on the next page we talk about that requirement disclosure, court approval timing, non-pro-tunc standards. You can try to get employed retroactively in the event you forgot to do it at the outset of your employment. Standards are pretty high. It is possible to get it done, but you shouldn't rely upon that. And obviously the sharing of compensation, it's an issue in connection with bankruptcies in particular, where if you're going to share your compensation with any other party, such as a finder, for example, it needs to be disclosed. I thank everybody for their patience. We're now at 12:05. I ran over a little bit, and again, I thank you. If you sent questions to me, I will attempt to address them and respond to you. You still have the opportunity to send questions later, and again, MCLE credit will be given for those of you who have requested it. Thank you much.